What owners need to know is that there's a law under which a squatter can actually get title to your property. So what the law provides, if there is an interrupted occupation, an interrupted and outright occupation of a property for a continuous period of 12 years, that person can actually go to court and get a court order to get a title. My name is Divinongaki. I'm a lawyer in Kenya. I've been practicing for 7 years. I'm a partner with Agema Analysts, which is a cross-border legal services firm. That means we offer legal advice across various jurisdictions. We have a presence in Kenya, in Nairobi and Mombasa. We have a presence in Egypt, in Cairo. We have a presence in Dubai, as well as Germany, in Hamburg. Property due diligence is an exercise that is undertaken by a purchaser or anyone intending to lease a property or who has interest in a property. Now, ideally, the end goal of a due diligence is to know everything that affects a property, everything that is material to a transaction. So if it's a purchase transaction, you want to walk into the transaction knowing every possible risk that could sort of make or break that transaction. So I would say that a property due diligence is a detailed interrogation of all factors affecting a property that arms you with enough knowledge to know whether you want to go ahead with a transaction or to pull out of that transaction. Now, a property search is a good first step in the due diligence exercise. However, a due diligence exercise should not stop with a search, because a search only reveals certain aspects about a property. For example, a search will confirm who the owner of the property is. It will let you know if there are encumbrances on the title. That means if there are interests that are registered against the title. So if a bank has taken a charge over that property, a search will reveal that. If a caution is registered on that property, a search will reveal that. If there's a lease over that property, a search will reveal that. Search will also tell you the area of the land, and it will also tell you, if it's a lease, the term of the lease. Yeah. Now, however, a search won't reveal certain other pertinent information. For example, a search will only record the area of the property as it is noted on the title. So it is necessary to undertake a physical exercise to actually ascertain that the area that is noted on the title is the actual area on the ground. A search also will not reveal interests that are called overriding interests. Now, these are interests to which the title is subject, but they are not noted on the title. A good example would be matrimonial or spousal rights, or communal rights. Yeah. So I would advise buyers that they should not stop at a search. A search is a good first step, but it is not the end of the due diligence exercise. Now, overriding interests are interests to which a title is subject. However, they are not noted on the title. What that means is these rights are protected at law, but they don't necessarily feature on a title. You can't see them from doing a search or from perusing a title. Now, a good example, as I've said, is spousal rights. So we all know that the law, the Matrimonial Property Act, actually provides that if property was bought during the subsistence of a marriage, it is deemed that the spouse has beneficial interest in it. The spouse whose name is not noted on the title has beneficial interest in it. So just from doing a search, it will only reveal maybe the name of one spouse, but the other spouse interest is actually still there. Another good example is communal rights, communal or customary rights. Now, we know in Kenya, land can at times be held for families. So families can nominate one person to be the holder of the title, but in trust for the other family members. So by doing a standard search, it doesn't reveal who those other family members are. And this is why a detailed due diligence is important, because it can actually catch such issues. a green card is a card that is issued in respect of RLA titles. These are titles that were issued under the Registered Land Act. So a green card doesn't issue for all titles. However, the advantage of a green card is it shows the history of all transactions on that title. So just after doing the search, you can also ask for the green card so that you see the chain of title, and you can also check if there are, other transactions that happened in between. Agricultural land is quite a contentious issue here in Kenya, especially with the legislation called the Land Control Act. Now, the Land Control Act, it actually gives prescriptions on how we can deal with agricultural land. It also defines what agricultural land is. It's quite an outdated legislation, and its definition of agricultural land essentially entails land outside municipal areas or townships, which is an outdated concept. Now, agricultural land in itself, there are instances where certain areas are zoned as agricultural. For example, the Mtwapa areas along the coast, some sections of it are zoned as agricultural. Now, what a buyer needs to know is that everything about agricultural land, every dealing with agricultural land is actually prescribed by the Land Control Act. So if you're selling agricultural land, buying it, mortgaging it, or even selling shares in a company that owns agricultural land, you have to do it in accordance with the provisions of the Land Control Act. Essentially, you need the consent of a land control board within the district where that land is situated. Now, there's a lot of misadvice on agricultural land. Now, most people think just getting the consent is the end of it. However, the legislation actually provides that agricultural land can't be transferred to a person who is not a Kenyan. So even if you actually do get the physical consent and you're not a Kenyan national, that consent is irregular and therefore void. Now that has wider implications because any dealing in agricultural land that is in contravention with the Land Control Act is void. Therefore, even if you're issued with a title that declares that you're the owner, if you got it irregularly, title to that land can be actually challenged. The thing I will say is that there has been little enforcement of those provisions, so we've not seen a situation where someone's title has been declared void on that basis. We haven't seen a lot of cases of that nature. Where the owner of a property dies, what happens legally is that property is taken into his estate. There are also prohibitions under the Law of Succession Act that prohibits dealing in property of a deceased person without a grant of probate. So the first thing that needs to happen when a person dies and you're seeking to either sell their property is that you need to get a grant of probate, and that grant needs to actually be confirmed. So it's not enough to just have the grant. The Law of Succession Act actually prohibits transfer of land until that grant has been confirmed, except in special circumstances where the court gives you leave in, where there are exigencies or emergencies of a certain kind that necessitate urgent transfer of that property. So as a buyer, when you're approaching sellers who are telling you they are the beneficiaries or they are the wife and they have the right to sell, the first thing you should ask for is the grant of probate documents, which have been certified by the High Court that issued them, or confirmed grant of probate documents actually. What buyers need to know about planning permissions, this applies specifically for properties that have been developed. It's important that whoever put up the building actually followed the regulations as regards putting up the building. So if it's building plans, they have to be registered with county, they have to have done an environmental impact assessment test, and NEMA has to have given approval for that development. They also have to have done a change of user. So they can't put up a school in an area that's not zoned to be a school. They can't put up a hospital or an industrial area in an area that is zoned as residential. So change of user and planning permissions are actually very important. You might be buying a building as the fourth owner and thinking that because no issue arose with the past owners, you're safe. However, we saw the widely publicized demolitions of buildings because they were put up in catchment areas. And this was years after the buildings had been put up. So it's really important to undertake a due diligence and see that if it's a building or a sort of development, it followed all the right procedures. And if they were not followed, you should really question whether you want to go ahead with that deal. Squatters are trespassers who actually take possession of property and they live there, and they can even establish residences on a person's property. What owners need to know is that there's a law under which a squatter can actually get title to your property. So what the law provides is if there is an interrupted occupation, an interrupted and outright occupation of a property for a continuous period of 12 years, that person can actually go to court and get a court order to get a title. It's called a doctrine of adverse possession. So I think it's incumbent upon owners to, at the instant someone comes into their property, either they should have built a boundary wall, or if at the instance a squatter comes to the property, they should actually either alert the police or start eviction procedures. Because leaving a squatter there for an interrupted period of 12 years can actually allow them to get title to your land, which is actually quite prevalent in areas that have a huge landless population. They will go and occupy your property, wait for those 10 years, and your title will be taken away from you.